I believe it's Johnson.
Good evening, Professor. Shall we start? Okay, hello everyone. Wherever you are, great your morning, afternoon, and evening. I'm your co-tutor, Qin Yue Han. My honor and pleasure to assist your learning today and tomorrow. One thing has to be emphasized again that if you have any questions, please type in the chat box and wait for the professor's reply. Now, please allow me to give a brief introduction of Professor Mei-Hsin Wang. You might have already been familiar with her name because every course of our summer school since the opening ceremony. Beside the personal profile of Professor Wang, you can read on the pre-reading materials. There's much more about the respectable lady. Professor Mei-Hsin Wang received her PhD in chemistry from Imperial College London. The Chartered Scientist certified by British Science Council, the Chartered Chemist certified by Royal Society of Chemistry UK, and awarded the Albert Nelson Marcus Lifetime Achievement Award in 2017. She teaches at National Yunlin University of Science and Technology with adjunct teaching in India and China universities and honorary guest professor in Hong Kong University. The topic for today's course is AI and Big Data Predictive Technology on IP monetization, case study of Globle Foundry versus Taiwan Semiconductor Manufacturing Company, which is abbreviated as TSMC. Now, let's invite Professor Mei-Hsin Wang to begin her lecture. Professor, please.
Okay. Thank you for Dr. King's very kind introduction. Can you hear me? Can everybody hear me?
Yes, we can hear you.
Oh, okay. Okay. So can you see my screen? I need to share my screen, right? I need to share my screen first. Okay. Okay. So okay. My interest would basic on monetization on IP. So today I would like to share you what I have done and what are my co-partners in the world. They have developed a lot of the tool, and they will certainly change your view how you can practice IP in your future career. We have to thank for the previous lectures. They have given all a lot of a very comprehensive and informative teaching, and I also have joined your previous course. So I believe you have learned all the basics. So today we will only give you the practical case. So in the later, if you need to have some test run, you may contact me, and then we can help you to do that. Previously, we are supposed to have the group discussion. I was wondering whether you can divide it into 4 groups to practice some software, but now the time is only 2.5 half. So I think I will skip the group discussion for the group discussion, and we go directly to the case examples. So I will start with today's agenda by the first one is AI and big data applies on intellectual property. And thereafter, I will give you the cases, how we proceed Globle Foundry's case when he intimidated a lot of company involved in US, in Taiwan, region, and also in China as well. And after the case study, we will continue for the blockchain apply on intellectual property, and then we have discussion and the summary for you to take home. The pattern values in every steps So from anticipation, which you may think from the prosecution of your patent, then after you have your patent, you launch your product, you may encounter the litigations, or thereafter you further would like to further monetize your IP before they go on the market. So we have to make decision based on the confidence through a lot of information, not only through a human being, but for AI, big data, and machine learning tools. And those intellectual properties tools, they could involve in trademarks, design, model, domain name, copyright, or even unfair competition. So for the litigation, you will certainly have to find out the killer arguments, claim construction, which has been taught by our first day lecture, Steve, and then also how we define the terms in the litigation. And also, if you want to choose the more profitable or more favorable court, where you going, where can you go? And if you find a patent, find a trademark, you may confront competitors will oppose your patent or your trademark. So how you conduct a primary search, and how to stop the pending actions. And also during the examination, we have to sharpen our arguments to try to get our patent or trademark proof as widely as possible, and how to refute examiners' objections. And we have to continually monitor competitors and emerging technology, which may take away our market. And also during the infringement events, you may heard about the foreign shopping. In US, you may choose some code they favor the foreign companies. If in Europe, normally we would think UK is more favorable for the defendant, but for Germany courts, they may prefer plaintiff. But for France court, it'll be by luck, because there was the judge's preference. So you need to know your killer argument, your opponent. You have to inform your user and the degree of freedom. You need to understand your degree of freedom to operate for design, or how you can design around to avoid the risk. And you need to find out the legal basics as strong as possible, and prove your novelty and your individual characters. And the overall similarity check, they can be done by a lot of the database. So in the future, you no matter your products on the market or is on pipeline, you have to monitor all the time. You have to anticipate patent refusal risk, the legal pitfall. So at the end, we wish we could own the freedom to operate. So this is just a very brief view. So in old days, based on our prior search, you may wonder to understand background about the judge or your opponent's attorneys, but there are so many juries and witnesses may not have a lot of information on public. Then you will have to guess. You have to try your luck. But with currently the new development tools, you can imagine in the future, you just wear your Google Glass or you use VR, AR, AI, VR tools. You go to the code, you can immediately scan, just like you look at the Iron Man. They wear the smart glass, so the judges will immediately tell you, this, for example, this attorney is the first time with this judge. Then you say, oh gosh, I have the winning ground because she's so green. You may evaluate the judge, or 89%, they will issue the summary judgment, or already been for the witness, you already participate 11 cases, so it's a very experienced witness. So for the juries, or for the single case, you have all the statistics background. So educator data, you can base on the personal experience and what we have done and information from the industry. We have the rough idea, the court deal with the case swiftly, but how fast? With the legal analytics, the average 212 days per patent days. In old days, we may think the judge prefer defendants with a lot of sympathy. And the company, for example, in old days, Samsung, they fight till the end. But after Samsung and Apple mobile phone war, now they prefer settlement. So it would be easy to have some prior search. But however, it's not so precise. But with the AI, big data, predictive technology, they will give you more precise data. 7% they favor defendant, and the company may settle in 95%. But however, will human we be replaced by machine? Certainly not, because even 95% the company will settle, but there's still a 5% you can work on it, right? Another examples. In old days, we apply on the law, the facts, all the rulings. But nowadays, the legal analytics, they will give a lot of strategy suggestions. So I will show you later. For example, if you are an in-house counsel, when you look at all those defendants, before you go on a call, you would have to evaluate, to calculate your winning rate. But before you do this calculation, you need to know where to find this defendant, right? So use a lot of software I'll show you later. But this is a case. When you first look at the pairer, can you imagine the sexier, the crazier, the flirtier, the sexier will become your competitor? From the English word, you may feel they are not so similar, but when they, after the design and put on the product, if you don't look it very closely, it's very confusing, right? And then if you work for the Google, this Google with trademark, this is the only one they register. But now even the trademark, they are very sexy. They train to change their shape and their wordings from time to time. So that some of the trademark, they have their metaphor, but by law, if you can recognize they are Google, then you cannot purposely to infringe them. But they are not registered. Google only register this one, but by law they are protected. So the mark is free now. Also the wording and the charts. Sometimes the word is not for or cannot be registered for trademark, but for the drawing, the pictures, the icons. How can you protect yourself? And what would be the perspective? You can check. You can have all my PPTs, so don't worry too much about it. For design as well, they register RAGAP, the product inside. But when you look into the products and the designs, there are so many different forms. Therefore, it's complicated for human beings, for us to do by hands, to catch all the defendants all over the world, or from time to time to protect your product, your IP. So now I will start to show you those tools, how they help us, support us to protect our rights and protect our assets. So the challenge is, first, we start with the company name. If your client asks they would like to register a company name, they have to brainstorm their name candidates. They have to vet name with the stakeholders, and they have the focus group or customer testing for research prior register. So finally, they may refine the name based on all those learning and go to file the trademark in trademark patent office. But somehow they could be similar to others, and the similarity sometimes is beyond your imagination. They could be very similar, but they may also look not so similar. So where is the boundary and how to do that? So this naming tool is based on Clarinet. You can go on their website to have some test run. So they can do a lot of work for you. For example, they can do trademark check. They can also do linguistic review, because sometimes the language is I think language is very difficult because there are so many countries. They are different language. Even the singular, the plurals, they could be different. Male and female may have different wording. And the similar word, the character, if you change to other language, may not be a good meaning. So somehow you can use the word with not very good meaning for your product. So the current tools, they could do the identical check. They can also do the identical check with other class. You may have already have the knowledge that the trademark can be registered in different class, by beverage, by medicine, by service, by different. They have about 45 types of the trademark classes. So, for example, I heard that there was one case in China because iPhone, they only register on the class 11, and that's for the mobile device. But the other domestic company, they register iPhone for the leather cover for the phone. But since iPhone did not register for the leather cover of the phone, that was belong to the other class. Therefore, the right was given to others. So when you give advice to your client, you have to think a little bit more. So the identical in other class, you have to check for that. Phonetic identical, or one word, one letter added or change, or later changes with phonetic prefix, or phonetic prefix, middle words, suffix, phonetic suffix, or identical situation. You all have to pay attention to that. Apart from the word differences, the country, the location is also important. For example, the system, they could conduct different search for English, German, Albanian, Zhongwen, Danish, Spanish, a lot of language. They could do that. And they could also have some status check for domain name, for allocation, a lot of different things we have to pay attention to. For example, here, if you have the trademark, you just one click, you tap in your idea check. So they will check the trademark, or whether they have been used in pharmaceutical, they have different rules, or in domain name. And the system AI, they will give you suggestions. So you will immediately find out, for example, this example that you can check worldwide, you have 30 to 26, 73. And then you can EU, you have 26 similar one. In Europe, not every country in join EU, so Europe is a little bit more country than EU. Or in the Middle East, you see all different countries. You can click the country and to see the check, and it was so convenient. For example, they could even give you the statistic check. So this is for trademark. That is for another sources. Another sources, it means the domain name or other pharmaceutical use or the other design, something like that. Then you can in EU trademark, they hit 74. One is identical, another two with the elements similar or quite similar, or in other class. When you click in this each icon, then you can see the individual one. So they even give you the EU, US, PTO, or Benelux, there's Belgium, Luxembourg, Netherlands, and United States, international registration. So if you don't use the certain tool, then you will be out of your work, because if human being just can't think of so many different wording, they will go possibly infringe your trademark, or you will be the trademark owner identified as a potential infringer, and they may ask you to change your trademark, or they may try to ask you for damages. And how they find out these words? So this is another tool in Collaborate. So they do, as we just mentioned, identical check for now for phonetically identical, or words difference, prefix, suffix, infix, and they may have the dictionary check, and they may have the consonant check, and thereafter they will also conduct non-dictionary and anagramics check. So you may ask, what's anagramic research? There are some I think they are another the methodology. They were, for example, if you have the world, there's marble, and they may reorganize the world to check the Blammer, Ramber. So you have to do this check by machine. It was impossible by human being. Then you may ask me, why we have to do that if we go back to the previous case? If you look at take a little bit distance to look at these 4 bottles, they actually will confuse the original brand. That's why when we try to identify the infringer or find out the potential competitors, or even we would like to reduce the risk for us to be the defendant, that we need the tools to help us. Another case, the SAC is custom search strategies. They could do the truncation. The word cannot, they were limited to 150 characters, but for us, that's pretty much enough. You may think, why we need 250 characters? Because somehow the brand could be a sentence. So, for example, vitality, the Vita bar, there was you check with Vita and star marks, that means Vita plus something, or prefix Vita in the back, there's some wording in the front, or Vita in the middle, there's some word in the front, or some character behind Vita. So they can do all kinds of check for you, and they can help you to filter your outcome, because those kind of software, they're quite expensive. So they based on the usage, the volume, the number you check, the things you want to download. So if you are in the company in a mega scale, you may want to refine your search, so you can have a lot of modified filters, and then you can even highlighting your outcome search. So they quickly give you a report. The current software, they help you to do the research. They also help to prepare your report. So they have some module, you just one click, you get all the report. So before we go into pattern, only in this trademark part, you may feel a little bit intimidated. Will you still keep your job? Certainly you will, because human will not be replaced. We are valuable based on our intelligence, our experience, our wisdom, and we still have to filter, to choose, to make decision. What is the really relevant and what is the strategy we want to choose? So now you can see they could show you how many trademarks similar to yours, they are active or inactive, or without the similar show the status. So you see different. Alphabetic similar, phonetic similar, or identical with a key element, or we use a semantic check, or you have other element 1, element 2 later in the front. So they can give you very detailed analysis, and normally just within less than a minute. And you can, this is another highlight tool. So you can see you can highlight an owner, because after you do one search, you would like to monitor the market situation or your competitors' movement from time to time. So you may monitor by owner highlighting, or you may follow by the goods. So you can choose different highlight for the future risk alarm, or a later email reports from time to time. You can decide you want to have that daily, weekly, monthly, or quarterly. So this is another example. After you've done all the search, they give you a very fine report, and you can click the trademark, you can click owners, you can also click the goods. So all this information, and you can also share the information to your colleagues in different countries, in another parts of the world. Previously, the case was mainly on the wording. How about the images? It's more difficult for real human, right? So, for example, if you simply just drag these icons, this image into this icon, you only need to do that. And here you would like to type few keywords or the code of the services, or you may want to enter trademarks. You may choose you want the color or without color selections. Within few seconds, they will check all over the world, all the patent trademark office, and gather you the similar trademarks with the feature and element similar to yours, and they could give you the most similar, the middle class similar, or they are only a little bit similar to your marks, and whether they are active or they are inactive. If they are inactive, you are happy. If they are active, you will be a little bit worried. And you clicking anyone you choose, you can see more information. And you can also choose when you do the search, you can enter trademark, enter owner, and you can refine. You can use Vienna domestic countries classification. This is a Vienna classification. And you have Vienna code list. And if you are not familiar with trademark 64, for example, you are a patent or trade secret experts, then you want to involve in trademark sometimes, then they give you suggestions, as you can see. If you type one, they will give you the similar one. They will suggest you maybe also need to check the other one, because it's not so it's very not very how can we say that? That means, for example, the knife. If the knife for the table, kitchen knife, there will be houseware, right? But if it's a big knife, they will be for another class. So they different country may have different coding. They will give you the AI will give you suggestions. Another case, for example, the Hoover. You design a Hoover, you would like to know whether there are other similar one in the world. So you drag in the photos, one of the images, they will quickly let you know what else in the world. And you can quickly try, you can also divide it by different country. So you can quick export them, you can highlighting them, you can fill them sort. For example, if we are in China, we're not going to sell our goods to Europe, then we don't have to check the Europe countries' trademarks. But when those countries, they want to import their product into China, they will certainly have to done the search. So we may only check certain countries, and you may wish to check all. That was up to you. And you want to design new trademark, a new product, then you also need to conduct the search. So last example is you can try. Here you see they have the Vienna class. There's a classification for trademark in Vienna. But if it's a design, then you can type in the display Lugano class as well. So that you have different searching tool. Then go to the litigation. If you class in the table, you can also easily understand this product, this specific product, or this specific trademark, whether they have been involved in litigation. For example, this trademark belongs to the company called Martis, and then they have been involved the case history. You can immediately show you collect that's IP. There's the clarinet purchased that's IP a few years ago. That's IP was originally from France, but now a merger acquisition is very popular in every industry sector, even in IP. So clarinet have acquire a lot of the useful tool and combine them together. So this is originally from DATS IP, and DATS IP they connect all the codes all over the world. So you quickly get that how many plaintiff this competitor have been involved. They have been 52 times as a plaintiff, have been 15 times as a defendant. Regarding these 52 times, whether they are the opposition actions, they are the revocation actions, or the invalidity, cancellation, infringement action, you can easily easily find out. And they will give you the report. So here is what I would like to show you. So this is the case report. You click in there and you will see the details of the content. They will certainly help you save time to prepare your case. So they also have the map to show you what happened globally. I would like to show you aspirin. Aspirin, this is a case for aspirin, and it was manufactured by Bayer. So Bayer, they have been involved in 1,417 litigation as plaintiff because people infringe their aspirin trademark. Aspirin, you know, the painkiller, very popular painkiller. But they also have been defended 2,372 times due to the aspirin. So aspirin have been a case history. So you can click in and then you will know what's going on. Globally, they have been involved in many litigations. So there are things beyond your imagination, and you may export those reports. So now you understand, without the AI or without the big data, without the predicting technology, it's very difficult to really carry on your IP work in your daily operation. So above is for trademarks, domain names, designs, naming for a company name, and then we turn into some patent tools. This is the tool I use to train my student, and they give you 14 days free trial. So thereafter you can try on this one, and you can just type a patent crawl app, get a register, you get 14 days free. So enough time for you to master or to get the flavor, a glance of how patent AI tools has been have been performed, they contribute to the work. For this system, they can do the due diligence. They can do quality check. They can also check your essentiality, whether you are essential standard, essential patents as well. So they do patent search. You can co-work with your colleague, and you can also do design search. Now I'd like to give you the standard. Of course, they have very informatic, a very well organized, a very complicated database. They have to write a program to determine essentiality for the friends. And they have solutions to check quality and validity. Validity, they have the certain standard for every country, but for quality and the value is case by case, because quality may have different standard and value depends on the market demand. But however, you all need to find out certain criteria, factors, standards, so then make this AI that can run. So how they do that? Normally they get all the invention and use AI and machine programs to check the claim construction and conduct the prior search. Thereafter, and they will give you suggestions and they give you evaluations for licensing transactions as well. So for those database, patent cloud is not the only one. You may welcome to you the Innograph now is being acquired by Clarinet as well. So Innograph now is belong to the previous trademark group. They belong to Clarinet. Is a very huge database source corporation or holding company as well. So you can try all kinds of the database. Just take the patent cloud as example. Certainly they have to involve all the major patent offices and all the database. Some of them they pay to get the data. Some of them they can get some free exchange because they may share some cooperation, they get it free. And actually you can have the AI or write some program to get, because patent office data are public information. You can download them, you can get them. Just if you have cooperation with them, you get them more real time. Because now they don't update their database every day, maybe every week, once a week, twice a week, once a month, depends. So you need the most updated database. That's you have to know. They have to organize their interface so that will be easy and very convenient for you to view the major prosecution and issue events during the re-examination or IPR inter-party review or business methods patents or post-grant reviews proceedings, file wrappers. When you go to acquire a patent or acquire a company, you not only check the value, the quality, you have to check the history, whether they have been in a lot of litigation. In litigation is not a frightening matter. As long as they win, that means they are more valuable, more powerful. So you don't. So we would like to see all the details before you pay, because for essential standard patent, each one they could value more than $1 million US per patent. So you don't want to pay your patent and then later on find out your patent could be invalidated or not powerful enough or not strong enough, or they have been already under a lot of litigation. So you can always check that. So if you go into the database, you try in Patent Claw after you register for your own 14 days free trial, then you can choose one particular patent, going to check their file wrapper. The file wrapper means from they file the patent to certain patent office, all the data they were public. But if you want to download that, they will charge you. If you can always free to review everything from the website, but if you want to download that or export the documents, then they will charge you for the transmission by the volumes. So you can download the documents and you can immediately, for example, here, this patent US 6909356, they have been rejected. The code is CTFR on its US Patent Office. It was rejected on 2004, October 13. Legal basis is 35 USC code 112 that involve in claim 22, 24 to 37. And this is about a specification. So they have the problem about drafting their patent. And they also have problem with claim 1 to 5, 7, 13, 14, 22, 24, 27, etc. And for this, they use this prior art. So now you understand they use which patent to invalidate your patent or to judge your patent are anticipated. So they was based on US code 35 US code 102. So 102 is about the novelty, and 103 is about anticipation. So they have different ground and different claims involve what detailed problems. You can use which prior art to invalidate that you can have very clear view, and then nothing can be hard. So AI and big data blockchain, they help the IP world more transparent. But in old days, because the transparency was low, so the people who learn this skill, they earn a lot. They could then now you know how those patent trolls, they are the people of skill in this art. That's how they could quickly pick up. For example, they could choose 1 or 2 patents and so 30 companies, and a lot of companies they would just pay. So sometimes one litigation they could 33 million, 20 million get. It's not easy money, it's intelligent money. But we have to say that they have done a lot of prior work. This is how I will show you later. But then, for example, this IPR, USPTO IPR post-grant proceeding, that means your patent is granted, but may involve a big market interest. Therefore, there are third parties, they want to invalidate your patent. So this IPR 2000, it was done 2017, they could easily be identified, and you can download all the information. But they will charge you, don't download it unless you really taking the case. For the practitioner, you can also see that. Let me start a minute. I found there's a question. I have sent you friend. Okay, so later. Okay, we just continue. So you can see what you have learned for the past, they are very important. They are the basis you can understand this information, because you can always get a lot of well-organized information, but you have to get the essence and make your decision, smart decision based on this essence, and then find and also develop good strategy for your product, your corporates. For prior art is one way to invalidate the pattern, but for the post-grant proceedings, let's see. For example, you can see the party involved in the event, the legal basis. 102, I would say, is a novelty. 35 USC called novelty. Then which claim involved and which prior art has been pointed out. So you can see that you can even download the documents, and you can download the whole file wrapper. So this is file wrapper search, semantic prior art search. That means you type in some wording, and they will, based on the word, expand the meaning to find a prior art for you. There are also secondary degree prior art. You know how expensive if you can find a secondary degree prior art, because sometimes there are some announcement on the websites. They will say, if you can find any pattern to invalidate or any prior art could invalidate certain patents, and they will give you the price for 50,000 US. But certainly the new paper or the new pattern or new similar arts, the prior art must be the things not involved in the company. Otherwise, they won't pay you 50,000 US dollar to find out prior art to stop their litigation attack. So you also have to conduct family prior arts. But don't worry, for the technical part, it's always very easy. You can easily use this software, but you need some training and you need some experience, because in this industry, experience still counts. The more you conduct research, the more you learn how to get the information more meaningful, more precise, and just down to the problem, can easily solve the problem. So when we search, they are the summary for that. It's a search profile wrapper. Those are vital activity from U.S. Patent Office PTAB, and the file wrapper corresponding to prosecution history, notice of allowance, remarks, or rejection. Rejection, if it called a CTNF, that's non-final rejection. If it's a CTFR, as we just seen in the previous case, that means that's final. Or it's a post-grant proceeding, petitions, response, reply, decisions. You can also easily find that. With one click, really just one click. As you have seen that we can done different search, right? Just one click. It's really simple, easy. One click and wait for certain seconds. But sometimes it may be a few minutes, because if your case is complicated with a lot of defendant, a lot of the events, then it will take a little while. So just one click, you can dig through layers of data to find out prior art. And the second part, we should find out the similar art. Prior art is for defending part, but find out the similar art is for you to find out the potential infringer, licensee, buyer, or cooperation partners. So they are different database. They will offer you different benefits. So AI will assist the semantic search algorithm, and you don't worry about the algorithm. They are mature. That's how they on the market already. Here, just another example. So instantly you can see your prior art, your first degree prior art. The prior art, I will show you. So you can just do that. First, we would like to explain what is the first prior art and secondary prior art. When you just check a patterns, examiner, they may have check some, do some research. you may also do search, cite certain pattern. So the pattern you cited, they were backward citation. But if you are a very profitable, very meaningful inventions, that definitely a lot of competitors cited on you. So those directly cited on you or you cited on others, they are the first degree prior art. But based on those backward citation or forward citation, they may cite other prior art and they are considered as the secondary prior art. Don't worry about too much about the detail. So now we go to more interesting parts here. Even the post-grant proceedings, you can very easily find all these data. You have family prior art check, secondary prior art check, semantic prior art check, or file record search. And you can easily just one click to get all these data. I will give you an example what is a double patenting in the later part. I have the example for you that will be easier. Claim highlights, new validity insights. So there's some basic for explanation, and now it's application part. How about the chart? You have seen the trademarks, they can easily have the drawing, but now we have to have the drawing, the images with the wording. For search, pattern also can be implemented. So if you want to make a car, you don't want to you don't want to infringe other like Mercedes-Benz or BMW. So you may want to collect your favorite cars and then design a run. So those tools also help you to design a run to avoid the risk of being sued by other companies. So it saves you time and they give you more target search outcome. And you can have the image cropping. You can have image with wording. And they also have advanced feature. If you remember previous trademark, they can specify with some certain elements. For example, in the car, we may want to have elements for the lights, different lights. And for the shoes, you put in one shoes image and all over the world trademark or design, then you can easily get all these similar arts and choose anyone and you guys click in, you know all details. And then for the monetization, this is the principle applied by this patent clock. Other system, for example, Intergraph or other company like Quest, they also have their different evaluation method, but doesn't matter. They all have their rationale behind, and they all sound reasonable. But sometimes you can have your first opinion, second opinion. So normally we check at least 2 systems before we make decisions. So for example, in patent cloud, they give the value their value factor is based on what? Their value factor based on qualification profile of inventor, qualification profile applicants, stage of technology life cycle, or how many citations there have been, whether they have been pre-grant assignment and licensing, because they are so popular, they are so profitable. So when they file a patent, they have after the early publication, then people already seeking for assignment or licensing. That's possible. For a quality factor, they choose the qualification and profile attorney, qualification profile examiner, the number of prior art or structure of independent and dependent claim that matters. You certainly can add in different factors on your own system. Maybe later on you develop your own systems. So this is just some reference. So those database, they have an actionable pattern intelligence, the machine learning power semantic check, and they have to do timing and accurate life cycle data, whether they are valid, whether they are lapsed, whether they expire, whether they have been under litigation. So proprietary pattern metrics and dashboard, they can provide you with multiple dimensional analytics on the quality, the true quality, whether the convenience for the image with the keyword search, design search, side-by-side comparison. There's the convenience for the software. This is the example. When you get in the pattern interface, they will show you the quality. For example, this quality C, value B. And you can check their family, citation, history, or original copy, all in one click. It's true. But what I normally do is, for example, if you are searching for the technology, this example. For example, blockchain, I check the blockchain, the pattern worldwide, and they could quickly identify their pattern quality profile. Not only you can understand the quality profile percentage with their numbers, you can also download those patterns. Then quickly you can have those pattern lists. You can download this AAA pattern list and learn from them, create your own pattern. Maybe even AI, they can create patterns. Whether that could be the patentee, that's another matter. And this is what I did for KEST. KEST is a Korean Advanced Institute for Science and Technology, the best graduate school for Korean. I was there for the consultant, so I helped them to identify. So this university, for example, you can quickly identify their pattern profile much better quality-wise, much better than a lot of the industry, because most of the companies, corporates, they have a lot of lousy pattern. For those D class, C class, B class pattern, they could involve more than 80-90%. Only very few good pattern, but KEST have a lot of nice pattern. But when you talk to monetization value, why value? So somehow you may ask me, well, pattern value, pattern quality. Good quality not necessarily reflect good value. If you wish to have a high value pattern, sometimes depends on your effort. You have to advertise, you have to promote, you have to litigate, you have to sell. So if you sell more, you license more, you litigate more, or you have a lot of advertisements even before your patent on the market become product on the market, that value will be high. So that human effort play a lot of the important role in patent value. So if you look at a company, they have very beautiful patent value profile. They also indicate you better don't go litigation with them directly. Maybe settlement would be a good idea because they master all these skills. They could have patent securitization. They could have a patent as a token for people to invest in a lot of skill. And this is ITRI. This is a Korean-based electronic technology research institute. Also very beautiful patent profile, but the value require a lot of effort because they are research institute and KEST research, they are university graduate schools, so they don't pay too much effort. They don't have the human resource, they don't have the effort, or they don't focus on the monetization. So there's the space for, there's a room for more efforts. Another things I would like to point out is the example how these analytics they could do. For example, if you they could easily find our company. I believe this is a company of my friend, the Fujifilm Holding Corporation. Fujifilm, after we have the automatic camera and we have a lot of mobile phones, smartphones, their business shrink a lot, but they turn their focus on biotech. So their business grow a lot again. You look at they could give you the proportional legal status. Pending, that means they also apply patents. They have over 10,000 patent applies. Under examination, over 8,000, active 33,000. But if you look at Japanese company, they have abandoned a lot because maintaining patent is a huge effort, and they will waste a lot of money at the end of the patent. They're getting more and more expensive for the later stage of the patent. That's why a lot of Japanese company, they tend to abandon at least about 40-50% of the patent. Then you can, how much is the, what is the numbers for those abandoned patents? That's 60,000, almost 64,000. But there was one time I gave a lecture in Japan for the Business Machine and Informatic Technology Association. All the leading companies, CEO, CTO, the IP councils over there, and I present all their companies' legal status, and they feel greatly relieved because it's not only single company that abandoned a lot. Most of the Japanese company, they abandoned a lot of huge amount of patent. But now they learn why abandon them, because we are the well-known company. We spend so many efforts on investing those patents. We can monetize on patents. For example, we can sell those patents overseas or to medium, small companies. They will be very happy to own our patent. We can also get some return on investment, just not waste. For those expire, that means they are all patent expired. There's no way, not too much concern. But for those revoked, that means they have been challenged. The patent have been challenged, and they failed the challenge, so the patent were revoked. But you may wonder, oh, why they have this weak patent? They are lousy. No. That means this 21 patent involved in big market. That's why people would spend millions attorney fees, go to the court to revoke your patent. And you look at that reissue. That means they win, they fight in the court, and they may amend. They may confront the PGR or IPR, and they succeed. They may amend certain their patents, or they may successfully defend this challenge, and they win. So that means they have been faced 40 litigations. If you want to buy a company, these two figures, they are very important, because each failure, they could cost you billions of dollars of the damages. So they could be a drastic catastrophe. So prior search, no matter you're doing litigation, licensing, or acquisition, trading, that's very important. This is another company, Toshiba. Now you see Toshiba have abandoned more than 51%, and that means 200,000 patents. And how many litigations they have been confronted? 127 revoked, 121 reissued. That means I think they are very powerful company if they could successfully protect their patents for 128 times. That means they are really skillful companies. So what I also did for companies, this is a company from Taiwan, SPIL. It's for chip connectors design. It's a leading company as well. So when I help them to maintain their patent profile, I will help them to grading their patent first and get all the list and keep the base one, A class, B class. And for C class, D class patents, they could sell or they could just abandon them. Otherwise, there would be a lot of cost and burden for the company. And for running this tool machine, it's not only for this system, for the other system are quite similar. They could help you for wording expansion. For example, I only can read Chinese and English, but they could help me to give German, Japanese, Korean, or other language. So for example, this is the search I did for protein. If I type in protein, and they could help me to find out the similar semantic wording, so I can choose different word. Then they could do wider, more comprehensive search. What I mean here is there are certain meaning, certain word. In patent field, they don't use the very obvious wording. They may have some ambiguous or more technology term. That's why AI helps. For example, protein. Here you see they have the not only different language. They have protein for chimera, different similar technology terms. They could help us to choose. And it also reduce the entry barrier. For example, I master in organic synthesis. So biotechnology is part of my knowledge profession. But if for people who are master in different field, or people that are very young, just graduate, undergraduate, just fresh working for first 2 years, 1 or 2 years, they may not be able to learn a lot of technology term. The AI will help you pick up different wording for you to expand the search to make it more comprehensively. So this is just the image. They could help you to do keyword expansion on related words, different languages, and can do multiple choice, for example, here. And you can check in different areas, for example, proteinase, plant protein, single protein, singular protein, or fish protein. You can choose what exactly you want to search for your client. Bacterial protein, high protein, human protein. So you just click, they give you options. And they give you suggestions, but you don't have to take them all because you are the real project owner. You are the one deciding which keyword to search, but they only give you suggestions. And somehow, if it's very new, very new, for example, blockchain a few years ago, if you click in blockchain, you can see what other words they suggest: cloud computing, cryptocurrency, Ethereum, Bitcoin, cloud-based, different Chinese characters. So they help reduce entry barrier for even young generation can participate in this IP intelligence. For example, if I type in artificial intelligence, as you can see, so many similar words they have suggested on different languages. So artificial intelligence, and they give you the human-computer interactions, machine learning. So even if you have the language barrier, they help you. For corporation, that matters as well. For example, Sony, they have many corporations. Even staff in the Sony may not know this much, but they can search for you. But as I have mentioned, AI is not everything. You will not lose your job because if you type in some very new company and they didn't know, they couldn't find the affiliate company for you because they get all the website information and all those database. But if it's too new company, you can't find anything. Your domain knowledge, your human connection, your work experience, they will certainly help. These just examples. So they could find out all the Sony's corporations if you would like to choose any of them to conduct the search. So here we have some summarized for AI and big data apply on patterns. So we can check file records. We can conduct claim construction. In old days, if you want to file opinion for freedom to operate claim construction, it will cost you 20, 30, 40, 50,000 US because it's by human. But now you understand if it's by machine, same complicated, but less human effort. But the cost, I wonder, cost depends on which front offer you. Will show you the true case in the second part. So allowance, subject matter, prior art, rejections, family search. So you can search file report, you can search pattern validity, qualities, everything. So, may I ask, should we have 10 minutes break or we continue? 请问一下，我们要休息10分钟吗？ Should we take 10-minute break or?
It's up to you.
Okay. Oh, I think can we take 5 minutes, right? We take 5 minutes break and we come back in 5 minutes to continue the second part. I was wondering you may faint it after so many information. So 5 minutes break for tea or coffee and we come back. I think it's 8:03 now, so we'll come back 8:10, right?
Okay.
10 past 8, 7 minutes. 10 past 8. Okay. 10 past 8. Okay. 10 past 8. We come. Continue, it's 8:10 now. So should we start again? Should we start again? Okay, so previously, I hope so. If any not smoothly running for the voice or images, just text message me or try to interrupt me. Or if you have questions, you're more welcome to ask questions. So we start the case now. So I mentioned I will only at the big we mentioned the case will be TSMC versus Globle Foundry, but we also offer some new cases to show you the current big data tools what they can offer us. So this is another example for the quality insight in pattern crop. We can demo the case for you. There was a Navist, they sue Micron. Micron is a mega company for chips. So they Navist, they choose 1, 2, 3, 4, 5, 6 pattern to against Micron, and we can see what the system can offer you. So quickly we can one click, simply one click. So you can for each pattern, you can immediately have the overview of the pattern, the history of the pattern, the claim analysis. When we mention the claim analysis, is that take into every claim in the pattern. Do we need to explain what is claim? I believe everybody should have seen at least one of the pattern. I was going to show you. I have one case. Pattern. I want to show one pattern for you. One pattern. That's IP. For example, this very expensive pattern. This pattern they settle with I think more than 12 billion. This is forever the biggest case in IP history about the bone transplant things. So when we mention about the claim construction, that means they take parts of the claim. So you see, this is US pattern. We want to see where is the claim. Claim is at the end of the pattern. So where from the place where they have a lump here, you see what is claim? That means they are claim. And this is independent claim. If a bone plate dimensionally secure to tibial bone, blah blah blah. So this one without additional numbers, aerobic numbers, they are independent claim. For those they have this, for example, the bone plate of the claim 8. When you see the claim, they have of claim something, that means these they are they are depending claim. They depend on claim 8, and claim 8 depend on claim 7. Claim 7 depend on claim 6, but 1 is independent claim. 12 is also independent claim because you see the 12 they don't depend on anyone, so there's independent claim. So I hope it's clear. This is independent claim. Those with the play of blah 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 claim something, they are dependent claim. The rest of part are mainly the specification. For example, the detailed description of the embodiment, they are specification, and they have the description for the figures. They have the charts. This is very, very expensive pattern. So this is examples. We just stop on here. And then we go back to check. So immediately, they will give you the claim analysis, and they will give you the claim insight. You click claim insight, you can see claim insight, family prior art finding, thematic prior art, file report. And here according to 35 USC, 101 is the patentability, 102 is a novelty, 103 is non-obviousness, and 112 is specification. We have seen in previous slides, they are claimed they were rejected due to certain reasons and using which prior art. So here by biography of the patent, they will quickly show that to you, and they will give you the potential issues for whether they will be challenged by 112, the median, the risk for 102 high, the risk for 103 median. So the system help you immediately analyze these 6 patterns. Now let's apply these 6 patterns to against micron, and we just have 6 class, 1, 2, 3, 4, 5, 6. 6 click, and we can analyze these patterns, strengths and weakness. So when we find out that 102 risk is high for this pattern, if you are micro, you will certainly check out 102 prior art to attack his pattern, this pattern. So if you can invalidate this pattern, whole pattern or certain part of pattern claim, certain claim, you don't have to invalidate all the claim, you invalidate few important claim, then this pattern will become very weak. They could not be used against you and you will win the case. Is it clear? Okay. So if you have any question, just let me know, because this is a very skillful and important class for you. This is what we really do in the real world. So whenever you say you have 6 patterns, this case 6 patterns, we immediately 6 class get all these parts, and we figure out your weakness. Your weakness is this one. Then we can check immediately 1 or 2 prior art and find out all the similar art against you. So here is a claim chart to find the gist of the invention. So here we can check for the claim. We can identify the claim element, machine learning by machine learning. Of course, human check. They learn. They have been trained for this system have been ongoing for 20 years. So they have been trained for 20 years, and it was developed by Foxconn originally, and that spin off become an IP company. But unfortunately, the founder passed away last year, my very dear friend. So this is the elements in the claim. I have shown you the claim. So here regarding this claim, and they could immediately compare and highlight for you. So you can very easily to make a report. If you are paralegal, you can quickly get a report. In old days, it may take you 3 months to compare this 6 pattern with all the prior art. Now you can do that in a week, but actually the machine provides the information for you in 1 day or even 1 morning, few hours. But you need time to digest and make a reasonable, presentable report and find out a strategy, how to confront the depends which party you support. You support the defendant or plaintiff in the court. You give in the analysis and report. So here you can easily see we have a claim analysis comparison. So we can find out the applicants argue whether the different claim invention and reference cited during the prosecution. So just this is examples. We can find out the prior art based on 102 or 103. So we will find out if we can, for 102 novelty, we can find out 93 prior art to support us to attack the plaintiff. For 103, we have 16 prior art. That means you are the paralegal, you have to read all these patterns, make a comparison. But as you see, AI help you. They help you to make the notes, and they have it highlighted for you, so you can easily compare all these information and find out the most meaningful. You don't have to compare 93 because the judge will also fed up. He couldn't read this much. You can find out the top, the most powerful pattern to attack the competitors, and you can easily compare the charts. So and make a pattern issue comparison. So here you see this pattern, the titles, they have been challenged by which inter-party review, if it has been challenged many times. So these two, they are the first time used for the litigation. And for these four, they have been applied, but take different big company already, because those are small companies, they may not have sufficient resource, manpower, or business resources to develop their own product. The one way is the enforcement for benefit. So here they could have the novelty challenges, and maybe have double patenting challenges. And they have the claim disclosure. Claim disclosure has been discussed by our first day speaker, Steve Chang, right? The first speaker, he has explained claim disclosure, because a lot of inventors, they submit a lot of information, and though examiner may feel it's not necessary, but it's good for us to do so, because once they approve your patent, after you have submitted so many patent, so many information, relevant reference, they could not use this against your patent later on. And also potential issue, indefinite. There's a USC certified USC 112 regarding the patent specification, and which prior art can be used to support your argument. They could give you a list. They have the 8 patents for this case, 34. So now you understand why attorney fee is so expensive for patent litigation. This Natalie Sue Micron with 6 patents, you have to search and study so many prior art to defend their attack and make the comparison. And they're really skillful. For the double patenting, as you think, there's a double patenting here, right? Novelty, you understand, and PTAB, you understand, claim disclosure, you know, indefinite novelty, you know, but double patenting, I'll give you a true example. This when I work for Takeda Pharmaceutical, we have one chemical. Actually, these three chemical belong to Takeda Pharmaceutical. It's a Japanese company. So we licensed this first to American company, and we license another one to European company, and we keep the base one for ourselves. So when we launch the product in the market, it's already very late. Patent is almost facing expire, but so we have a lot of similar biosimilars on the markets where we have to defend, we have to litigate all over the world. So in this case, I want to teach you another mean wording. You may have heard in the patent world, the teaching away. What is teaching away? Teaching away, that means, for example, you see, this is the mother structure for the molecule. Can you see these parts? These 3 parts, they are same. They are the mother part. And these 3 parts, they are different. They are the side chain. That's what we call side chain. Normally, we think the character comes from the main part. The side chain plays small influence. But however, in this case, it's different. Because we have the troglitazone. It was launched in US for Park Davis, but the liver toxicity and the kidney toxicity was high. There are 27 patients passed away during the clinical trial. Therefore, the clinical trial was withdrawn, and the company was acquired by Pfizer. So this product was not a success. And then we start to worry, where is the problem? We don't know it's the mother part or the side chain part. And the second product was licensed to Globle Wellcome in Europe. But it sells very well. Then we understand one thing. The toxicity doesn't come from the mother part, it's from the side chain. So this one should be safe. And we conduct experiment on animal and human. It's really good. So we launch this product by ourselves later. This is teaching away. That means from the human experience, from the past experience, we think the moleculars, the main efficacy come from the mother part, but this is different. You have to do experiment to prove the efficacy. Therefore, the patentability should be sustained. They should not be surrendered. They should not be give up. they should be issued. That's why the patent is allowed. So this is the teaching away. As long as you can prove it's teaching away, therefore the patent is approved. And this is the explanation for example for double patenting. It's also come from this litigation, because in different countries we saw different defendants. It's this US litigation. So the defendant, they complain target of pharmaceutical double patenting. Now you understand this is what we call the main part. This is the side chain. We filed this 779 patent long time ago, because when you first have a molecule, you may test on bacteria, test on virus, test on small animal before they go for a big animal clinical trial and human being. Therefore, you can't wait until the end to file patent. You have to protect from the beginning. That's why we claim they have the blood sugar, blood lipid control efficacy. But later on, we choose different, we conduct more experiments and we choose different molecules. When they have the L1, L2, that means they are the ligand. R1, R2, that means different side chain. So we change slightly. When we mention change slightly, we give you example. So here you see the mother part, they have different part of this part. So this is a side chain. This A could be so many different. When you come back to here, you can see the L1, L2, R1, R2 could be so many different compounds. They could couple hundreds, 200 compounds. And then we finally select few of them. And in the pattern, they will list what is R1, R2, L1, L2. They should be different. But definitely, the molecule in 200 already covered in 779. We choose something from 779 to conduct more experiment on sugar control, blood sugar control. And finally, on the market, it's these two molecules, 777 patent. So this belong to the molecule has been covered in 200, and the molecule in 200 certainly covered by 779. Therefore, the smart defendant, they say, oh, you target double patenting. Not only double patenting, triple patenting, right? But if we have conduct extra experiment, we prove the better blood sugar control, or we claim it's a diabetic medicine, become a medicine and become a supplement, or become certain full nutraceutical or different. They were different class of different class of the experiment. So here is, if we have advanced experiment, and we are actually narrowing down, we prove they are better with certain experiment. For example, the malaria, they used to be treated by medicine, they extract from a tree, but later on I found a medicine they could be used to against SLE, some autoimmune disease. Although this character already embedded in the previous medicine, but it was found later, not in advance. Therefore, you can use the hindsight, you can use your current knowledge to hinder the patentability. So this is how we can overcome double patenting. Of course, we patent again, but the claim are different. We should have slightly sugar blood lipid control, but we don't know the dosage, right? We don't know we have to use the medicine for how long. So we finally pick out some of the molecular from here, and we claim it's a blood sugar control. And later on, only this one. That means this C2H5 is on this position and this position. So there's two molecules here only. And they could be maybe 100, maybe 300 molecules. So if you have continuously making more and more experiments, for example, there are some medicine they could treat endometriosis, and they could use to treat breast cancer, and they could later on they could treat they could be applied for IVF for tube baby, test tube baby, or they could be used for additional indications. They stand on the ground with their evidence to get the new pattern for new indications. I hope this have explained the double patenting or some basic knowledge as well. So this is also proof AI or machine learning or big data, they could not get rid of us because we human beings still have effort, because experiment, they have to come up by men, come up by, of course, they say white men, not men and women. But anyway, men is a general term for human being, Okay, so you see that this is explaining what is the whether it's obvious or double patenting. And then I would like to explain what is obvious in the chemistry field, because I actually have a fellow in the Royal Society of Chemistry for my first major was in chemistry. So if the motive to pick a compound here, why we can continue to file so many different patents? That means because the motive to pick a compound, we want to pick A, B, C, D, F. Why you choose them? If you choose them, for example, this is some domain knowledge, we call domain knowledge. For this benzene ring, this is sigma ring, we call it benzene. Benzene ring, they are lacking electron. If your side chain is electron rich, that means they lack electron. If we take electrons money, they are sucking money into their rings. So they will be too easy, they will be obvious. But if they are this carbon, hydrogen, they are nucleophile, they are not electrophile, they are not rich of electron. You want to add this chain into this benzene ring, that will be difficult. You need to have skill, you need to try different methods, you have to add a lot of effort, different condition, pressure, solvent, whatever. Then if you have to put additional effort, it's not mandated, then your patentability should be sustained. So that means if it's a nucleophile, the patentability will be wrong because they'll be too easy, they'll be obvious. If it's an electrophile, then it'll be yes. So that means by different domain, they have different way to overcome obviousness, and also have different manners to defend double patenting. There was some technical issues, and of course the technology, they could explain why. So you sometimes heard they have the expert witness. The litigation fee is so high, the courts, they will charge you. The expert is also very expensive, right? Especially need to understand a lot of knowledge behind. And the attorney expensive, and the patent attorney or patent agent to support the attorney also very expensive. So this is the case where I want to show you. Here, portfolio sustainability. We can, before we check those, first we have to check these 6 patents, right? We have to check these 6 patent quality. We also have to judge. You want to settle or you want to fight until the end. We have to compare this plaintiff and defendant's strengths and weakness. So here you can see this is the brief summary for Natalis. So quickly we can have a profile about the plaintiff. They have 100 patents, and they have 23 pending patents in active 42 because they are small company. They can afford to keep big company, as we have seen. Previously, we have seen those rich companies, they could afford to abandon, this is Toshiba, right? They could afford to abandon 2,000 patents. Their size is certainly different. Okay, so this is, so we can compare the patents, we have to compare the technology, and we have to compare the core competence between 2 companies. So this is the comparison. So for this is a Natalis and this is a Micron. You can see their pattern very different. So this 12 pattern value high, right? The quality and value. For Micron, they have more pattern, but the value was less variable. So you can have the statistics store different. You can search the top 1, top 2, top 3 potential licensing. They can also help you to find out these 6 patents could file litigation to against more, find out more potential plaintiff or defendant. And this is a comparison between Micron and Netlist. You can have two company comparison. This is the pattern quality and value analysis. So certainly Netlist is the pattern tool, because as you can see, is that beyond the macros view, specific quality issue for each pattern, we have to examine instantly. 88% of Netlist have US family members challenged with eligibility or novelty, and 25 have US members challenged with novelty. That means their pattern really good, and they also sue many big companies. A lot of companies, they also would like to invalidate their patent to avoid the future potential risk being sued or being asked for royalties from Netlist. But Netlist have to fight very strongly to gain their rights, because they are not a performance, they are not a manufacturer companies, they are the patent owners, they are the trolls, so they sue many companies. So here you can see with the eligibility, there's the analysis for a profile. The 6 patents, 6 families are in risk. For novelties, the 25, non-obviousness 36, and fairness 24. If I got a report like this, and I am the defendant, then I will fight till the end, because I will understand their patent will be very easy to be invalidated. As we have seen, they use 6 patents to against Micron, but however, we found out they are not very strong, right? Because 94 similar arts, 14 similar arts, 8 similar arts, except this one. This one I will be very careful, because I couldn't find any similar art. So this will be most powerful. This will be most easily to get rid of it. So find the statistic that help you to make the decision whether you want to find, you want to settle, you want to buy the patent, or maybe you want to just acquire this company if it's so small. If I'm the owner for the Micron, I may just purchase this company and use this company to against my other competitor, right? Just don't sue me. I buy you, I buy you this company, become my own affiliation, and they could help me to against my competitors. This is another strategy in the real world. And sometimes the litigation is also the purpose like this. They want to show their strength, get your attention, then you may want to ally with them. So the technology follower for patent licensing or buyer. So from these 6 patents, they could find out either they could sue Google, Rambus, Intel, Samsung, or Hynix. This is the we just give you some examples. So that's why they sue Micron, right? So find the similar arts, and you can find your potential buyer, your potential royalty payer, or buyer, whatever. This is the analysis, how the pattern analysis. If you are a big company, you have different strategy. If you are a startup company, somehow you want to get attention, maybe other people will invest on you, or you can form a new affiliations, or you can have other cooperations. Okay, so due diligence, the patent in suit. Right. So here, another analysis, those 6 patents, when will they expire? Because sometimes if patent expires soon, then you don't have to worry. But for example, they will expire 2032, they are 10 years more, then we have to pay enough attention. And they have 7 patents in the family, and this is a big family. They have 18 member patent in these patent families, and filed in different countries. The patent will be expired 2029. The potential target, they can sue Korean SK Hynix. And it was once being the family abandoned. They have been abandoned because people already noticed. So you see, Japanese and Chinese, they already pay attention to avoid their families, to secure their business. This is also very. So you can see American company and Korean, they are very careful about these 2 patents. So they already attack them. So they have to abandon 2 families. That's the rest of the patent family. So now this is the demo, how the the due diligence could be conducted by AI, and you certainly realize one thing. You have to study very hard in school to get all necessary knowledge, but you still have to learn new skills because the world is changing. It's no longer that simple. The AI big data make our worlds easier, but it doesn't mean we can work less because the machine, they create data so quickly. We have 15 minutes left, so we don't take a break. We go to the another demonstration. Globle Foundry case, they sued TSMC. As we have many Chinese students, so I will show this. Stay for 5 seconds, and then they could understand. I have English version. Don't worry. So here there was 3 years ago. Globle Foundry, they filed 19 patent lawsuits and 2 ITC, International Trade Commission. This is a very huge move. They filed 21 litigation at one time, right? And they sue how many companies? Apple, Broadcom, MediaTek, NVIDIA, Qualcomm, Xilinx, and then Digitech, from the whole supply chain, actually whole supply chain. So in English. So this is a quick overview. So Globle Foundry, actually, they are prepared to abandon the DRAM business. So they sue all potential buyer and licensor. So those defendants have to study these patents carefully, deciding whether they would like to settle or like to buy their patent, or whether they could buy their factory as well, because they are moving to new business. What about the rest of the assets? So let's make a strong show. So here, there's the #1 defendant is Taiwan semiconductor manufacturer. In this lawsuit, if they file in ITC, that means they want to buy your product import into US. And the technology belong to iPhone 10X, Apple, processors and chips, whatever. And this is the Globle Foundry list. The #1 TSMC, the #2 Globle Foundry, #3 UMC, #4 Chinese 中芯国际 SMIC, Chinese Hongqiao, Taojix, Lijing Power Chip, that's in Taiwan region, Vanguard, DB High-Tech, Fujitsu, and others. So you can see this huge percentage gap. The #1 TSMC, there was 56.6%, and Globle Foundry, they took 11.2. That's the same. #2, #3 UMC 9.3. So you understand this market a little bit. The Globle Foundry, you have to understand, as we said, we compare with patent, we also compare with both defendant and plaintiff. So why are we doing this? Because somehow, if you remember, we do the company check. There are a lot of companies that have been gone through many merger acquisition, but the patent still under the previous company. They did not change the assignee because they will be too expensive, too complicated. If they buy a company 3 years, sometimes they could have merger acquisition several times a year. They will continue waste the money for changing assignee. So most of the time, they don't change unless they file new patent. They will have the new company name for the new patent, but for the existing patent, they don't change. So if you if you use we have Google patent, yes, but if you use patent cloud, you click Globle Foundry, you will not find the full patent, because a lot of patents are from their previous company called AMD. Here, as you can see, Advanced Micro. It was a spin-off by this company. This original shareholder were Advanced Micro Device and Advanced Technology investing company, another company. They are from Abu Dhabi, UAE. So they were Middle East investor and AMD. But finally, this Middle East ATIC, the investing company, they acquired the full right, their equities from AMD. So now it's 100% owned by this UAE company, investing company. Globle Foundry have a lot of cooperation with IBM. Therefore, a lot of patents, they were still under the assignee, still under IBM. They did not change, but by contract, they belong to Globle Foundry. So if you check the patent owner assignee, without AI, without big data, how, as we did in previous slides, you will not fully have the full comprehensive view of Globle Foundry. I'll show you later. And TSMC is originally from Taiwan region, though, so it's less complicated. But if you check from the USPTO, they have more than 20 names because they have a full English name, they have abbreviation, and they have a different way of typing. For example, they could be Taiwan Semiconductor Manufacturer, CO, or LTD, or different, because they have different law firms, different patent agency to drop the patent for them. They may have slightly different wording. And TSMC also went through a lot of merger acquisition. That's why a little bit complicated. But here we can see this a quick look for the review of total 19 complaints. It was mainly in Delaware and also Texas. So we can quickly, as we previously mentioned, we have to review these patents in suit. So those patents, whether they have been going to their RCE or their final, non-final, have been re-examined, whether they have went through exam, whether they have been challenged, and whether they have the risk in 102 or 103, have they have any novelty, eligibility issues, or with their file history, we have to gather them all. So this is one of the patterns that show the quality C, quality values A, that you may ask me, what quality C pattern used to against so many countries? He want to solve the pattern. They don't want to maintain the pattern. They don't even want their factory. They want all these defendants to take great care, big attention, try to see whether they could sell all these things without abandoning them. So here you can see the pattern, the current assignee is Globle Foundry, but originally it's from IBM. Here you see this is another pattern you can overview. They have two events. They have prosecution histories, and they were issued, and so this is very successful filing. And they have 10 family, and they have 23.6 prior art. So this is, you can see where they file their patents, WIPO, EPOs, whether they are pending, active, inactive. We check if you look at the pattern with quality AAA, then you will be very, very careful. On value add, normally when pattern, if they have been involved in litigation, they'll value immediately increase, but it's abandoned pattern. Don't worry about it because they fail to respond to office action. Why sometimes they fail to respond? They probably because they don't think they have strong arguments. They cannot convince the examiner, or they think they are not going to develop this technology. They just want to give it up. There are various reasons. The simple family, standard family, citation, history, original document can all get it from the system. And very computer, just one place, few clicks. So similarly, you can have all those examiners events, different one. What they have been done, they have been classification. All the history cannot be hide. Then not everything is transparent. So this you can do the conduct the side-by-side comparisons. Side-by-side comparison, understand their every patterns of family histories, where they have been belong, they have been acquired original assignee, they buy the pattern from Fujitsu, Hitachi, AMD, IBM's broadcasters. So where the patterns from, you can also understand, have the full picture. So this is the pattern issue list. So you see these few patterns have been used against these 20 defendants, whether there have been rejections, there have been the rejection prior art reference, family members, abandoned families, qualities, original pattern, source. You can all conduct that. As I mentioned, we don't just trust one system. I always conduct the second one. So this is another second one. For pattern crop, you get those pattern grading in ABCD, right? Where are the bases? Remember the 1 or 2. For pattern crop, their qualification principles here. But I used another one. It was also developed by the #1 patent troll in the world. They have been used the system also for over 20 years, filing over 1,600 global litigations. So this is another way to evaluate a pattern. So they give the scores. Previously, they give the ABCD for grading, but here, this system does it can give you the overall score. What does the score mean? That means it's number 69. If we classify the whole work, similar arts, you say standing on 69, that means you are not very powerful. Is there any case that could be 0? Yes, if it's 0, that means everybody have to pay you. If you sue anybody, you are so original, they have to pay you. So we normally would judge on this analysis. We can decide whether we should fight or we should cease the fight for settling. We can conduct the analysis for the whole pattern, and we can conduct for individual independent claim or also dependent claim. And we can also go into further for the claim elements. Claim elements, this have been explained previously, right? For a claim, they may have certain elements, and we can, based on the elements, also find out a prenup. So here, I will take an example. For example, you look at a person, you may say, oh, he's very handsome, 90 score, you give him 90 score. And then you may think then later on, where is his specific features? Oh, she's pretty and well. Oh, beautiful face. Okay, face 99. You give him the grade 99. And what is his she can play piano. Okay, so she's fingers, it's good. So maybe fingers 85, you give a different score, right? But since he spends so much time on his beauty, on her beauty or his beauty, playing piano, he may not be good at exercise. So sports for his legs, they are the I will compare your head, your hands, your legs as the independent claim, and then your fingers on your hand as a dependent claim. So all the elements. So for this zoo system is more detailed. This is very focused on litigation. You can have the overall score for one pattern, and you can have the scores for independent claim. For example, your head, your hand, your legs give different score, or even the elements for the claim. If your hand is one claim, and the fingers will be your elements, can give different scores. So it's going very detailed of final prior for you to fight for the litigation. And then you understand why there are some companies, they are so powerful with 1 patent, 2 patent, they could sue 50 companies in one court, or they can sue 100 companies because they use the system, quickly find out a similar art in the world, where are the potential infringer. And now you also, after today, you also understand, it's not only patent, trademark, domain name, design have the similar tools as well. It was only whether you want to start the fire. If you have time, you have money, and your company or your client asks you to do so, then you conduct all these tours, gather all the necessary information, and then you just kick off, start your fight in the law, in the court. So this, as you can see in the systems, if you click all, you get 1 score, right? And you can have an independent claim, and you can click individual one. So they give you the layer for the claim structure. The claim 1, claim 9, claim 12, they are independent claim. For claim 2, the rest, they are dependent claim. Claim 3 depend on claim full. Very easy. And for the claim, they could cut them into elements for you. I'll show you in the later figures. In this system, you also, with one click, you see the claim, spec, reference, forward citation, legal events, images, relevant art, foreign families, US families. You can do the comparison check. You can do individual in a single view. So there's nothing can hide in the world. So for the citation, this is the first degree reference. If you find the citation in this cited reference, there will be secondary reference, as I have told you before. On the legal events sometimes very important. I want to show you here. You see, they have paid the original patent owner. They are Globle Foundry, right? But from here, you see, they have been securitized to a Wellington Trust National Association on when 2018, November 27. That means they have started to initiate this patent war from 2018, November 27. They borrowed the money from Wellington Trust. And the patent was given back on 2019, August 21, and they filed a litigation on when? August 26, I remember. So this is why this legal event, they reveal a lot of the information. If you have, after the search, you assign the monitoring or the warning alarm to send you the following reports, then you will immediately find out your key competitor may have some move. When they suddenly borrow big money from the bank, from the trust, that means they are preparing the big five for later, or they may have some major move to build up, maybe some good intention to build a new factory, find new indication, clinical trial, or marketing events, not necessary litigation. But this time it's litigation, so you can see this information exactly revealed. And I want to show you the proof. I want to prove what I told you before. So they start the litigation on August 21, right? August 21. And when they give the patent back, they have 26 give the patent back. But this 5 days later, they file a litigation. So they borrow the money. They have to pay the people to study the patent, right? You want to sue someone, you have to study. And you have to write do a lot of paperwork. And here, related art, the reference, forward citation, this is the pink one. This is the overall. So you can have different views. Patent families. And I want to show you how they really pick the target. We mentioned from this place. Here you see we can identify the independent claim, dependent claim, and then we can have the overall score, right? I have shown you the score I have done. Actually, I did it myself for teaching. Every my student, I have been teaching it for many years. They have run through this. They know how to do that, but I don't know how profitable they have done. But you need to do everything correctly, because if you make one thing wrong, and you will lose your client's trust, you won't get another case next time. And they would really expensive, very tedious, very sophisticated analysis. So here you see this pattern in suit. I did it myself to analyze the overall score, independent claim, and for those claim have involved in detailed arguments, we even analyze their elements. So why they sue TSMC first? After we went through all this analysis, I want to show you that, for example, claim one, they give you the here I want to show you. They give you claim chart. So here they show you the claim one. They have 3 steps. So they have 3 elements in this claim, and the score is 56. And here they will pick up 80 more similar arts. and you can click in the pattern and they give you the mark. So you can see who is more relevant, and they have the overall score. There's the first 25 pattern, most similar pattern, give the average score to see who are the similarity to yours. And they have different scores, A, S, C, R. A is the abstract comparison, S is family, C is international classification. Whether you are in the same class, your family, pattern family, and use AI to give the grading. You can download them. You see here at the download, right? And download them. This is the outcome for those download. And you can identify the yellow one, they are TSMC. That's why TSMC become the #1 defendant. I've checked them all, but because we have only limited time, I just show you some cases. This is a claim chart. See, they give the limitation. I told you they will cut the claim into element. In old days, you have to hire a patent agent or patent attorney to do that for you. Very expensive, but now you can have AI do it. But patent agent or patent attorney give a review, certainly spend less time of the patent attorney, you can save your cost. But it save the cost for the law firm, not necessarily save the cost for your client, because client pay the same. This is law firm need to have this tool. Claim, they have the claim chart, they give you a claim chart, and you can see the claim assignee, the assignee history. And I want to show you particularly, we have to watch the time. If you click one of the pattern, you click one of the element, they can do cross comparison here. So it's like a pattern crawler, they could have the highlight for you to make the report. So this is a comparison of this pattern and this element. You can compare with the whole claim. Whole claim, that means the whole arm. You can also compare with one element. That make you very sophisticated, very precise to attack in the court. How you could explain. And this is another pattern. Again, you see the quote. Again, the yellow one is TSMC. You see this, there are a list. So they give you which pattern, which company, which claim, the similarity. The similarity low, that means you come against them. The similarity is high, that means you are so similar. So this is the indicator for you to find the defendant, licensees, buyers, future partners, depends on your strategy. And this is a claim night. Again, you see the yellow one is TSMC. That's why the TSMC was badly, they use media, try to ask TSMC to settle with them. Actually, this case settled within 3 months. I will show you the end. So we quickly go through this. Another claim, another pattern, TSMC as well. Another pattern, their pattern, quality good, value not very good, but after the litigation, the value were up, will increase. So you also have the claim structure, scores for claim 1. Again, we see TSMC and other plaintiff defendants could be found or future licensees. But TSMC is the #1 chip manufacturer in the world. So September 13, that means 40 days later, less than 14 days, those 5 weeks later, TSMC, they filed multiple lawsuits as well, but not as many as the Globle Foundry. They filed 19 patent, 2 ITC, right? They filed lawsuit in Germany, US, and Singapore. Certainly, they have to search Globle Foundry's patent profile, compare their own to raise the case in where they feel more vulnerable. So according to the press, 25 patent in question that involve a lot of technology. There was a FinFET, but for the technology, you will have my slides. You can read it later. I would like to have some time for you to ask questions. Okay, we have 25 minutes left. So here we see again. Now you understand. This is the pattern comparisons for prior art, whether they have been in some events, how many reference, prior art, and you can view them just one click. You can see the patents history, where they are, on the strengths of the patents. They could compare. They are the inventors. You may also analyze the inventors' histories, those patterns, their family, whether they are still existed, whether they have been involved in AIA. The AIA is in 2011. The American, they have amended their Patent Act, so you can have the business master patent review, post patent review by counterparty or third parties. And this is a claim element. You can compare with the claim element, claim chart. So then we can make decision with great context. We can save time, save real cost from the analyst, but not necessarily from the client, because the law firm certainly do not want to cut down the cost from the client, but they cut down the cost from the law firm, definitely. And optimize the legal strategy. We can prepare the case faster, minimize the risk, identify class for availability, for search, watch, or monitoring, and we can assess the likelihood of success. And then I would like to, that's the few case demonstration. Now you understand in intellectual property, no matter it's a patent, trademark, domain name, design, or anything related. So now we go for the money making issues. I think everybody likes it. We study hard. We want to have a good life, and if you can help your client make fortune, you certainly will enrich your life as well. So there are people that think IP Week. It was developed by IP Week. Also my friend, and he used to be the #1 troll in the world. Therefore, people are intimidated by him, empowered by the AI analytics. So if you want to get into this IP business, you need to rating your patents, evaluate that. You need to answer your buyers, whether they're valid, whether quality, where could they be used, what is the current status. You need to answer all the answers. Financial insights, so they have their standards. So you have to reveal value of the IP and their risk. You have to build the history of the value. You have to cut transaction cost. You have to have your IP budget and strategy. So blockchain, they apply the blockchain. It's a very idea and very good vision, but it takes a while to be successful. It based on if everybody is on the blockchain, including all the companies, patent office, but it takes time, take a while. But actually, many leading patent offices, they are experimenting or planning blockchain to be involved, because we want the true information, real-time information for patents. So first, we have to search with whether the patent is existing, who is the owner, where to contact that. If you don't find the contact person information, how could you transact or collect the royalties, fees from those patents or those users? And we have to make it interactionable, not only for information, but also for transaction. So they use a blockchain with smart contract. There was Ethereum, right? So the IPO, they could cover various models. You need to build a model for patent grant, patent annuity payments, patent sale, patent licensing agreement, patent pool, title confirmation for SAP, for patent alliance, patent-based lending, tokenize. They have their own token. They will be easier for everybody to exchange the rate. Then defense aggregation and mutual non-aggression pact. So I'll give you an example. For example, previously we use most of the company use CPA Global software, and they will charge you $75 US. That was average because, for example, they may charge big company, very big company in Japan, just for 10 US for one patent. But this company, they have more than 500,000 patents. Of course, the value different. But I am aware he charged one of the Taiwanese company $130 is 130. So, oh, why they charge Japanese company 10 US dollar, Taiwanese company 130 US dollar? Because this Taiwanese company only have 10,000 or 20,000 patent. I mean, oh, 10,000 patent. That's a lot. But the Japanese company, they have 100,000 patent. So the value, the cost will be different. And then you have to pay US attorney and Japanese attorney, and you have to pay patent office. So they will add up the cost. But if everybody is on the blockchain, right? Everybody, you pay an assistant and they go directly to the patent office. So you wipe out the middleman. So they said, we charge 30, but depends. Then you cut off the law firm's fee, and patent office will be happy because for the patent owner, if they have extra money, they could maintain more patents. So the only people unhappy is the law firms or the agencies. So this is the very convenient system. For royalty as well, if you want to collect royalty, you need to hire people, and the cost will be high, and you can save the cost if everybody is on blockchain. The conditions, everybody on the blockchain. So you pay to the system, and they go to the licensors. This is a brief introduction for the rules. The second system I introduced. Of course, they have AI systems, machine learning. They could make the comparisons and try to give different scoring. So they give you the scores for quality and for the value. So these rules, they have trained over decades. They actually file more than 1,600 global litigations to fit in the data, train the system. I and my student, we have helped them to invalidate the data from CFC. Actually, they're quite fitting. We compare with the patent quality, we analyze and compare with the outcome of a court ruling. If they come to the same result, that means the system is trustworthy. The quality value could be analysis, and they have easy management for corporate, for self-use, licensing, trading, securitizing, or litigation. Okay. So this is the view for this system. And you can do analysis, you can contact each other, you can register with smart contract. Smart contract is not paper contract, it's a program. So they can use the program to help you. And they can do the annuity payment, pay the annuity, then could pay a patent license, and they could pay assignments, standardization, identification, patent pooling. That means if you have a new technology, you want to find your own patent alliance, you can raise your hand. I want to have this specific technology. Everybody join me, and then you can have your own alliance through this system. Or title confirmation, aggregation, non-aggregation pack. That means here that means even the patent owner, you can give your patent to MPE, and the MPE will help you to do the litigation or something else, or collect the fees. Patent-based lending, the patent securitization, tokenize, because what it means, they consider patent is like the real estate. They all have the certificate. We have the patent certificate, right, from the jurisdiction you have filed. Of course, if you don't want to invest on one patent, they divide it into certain equity, and we can invest on a certain equity, and they turn that equity into the virtual token, monetization of token, and token exchange you can invest. That's very convenient for small, medium, or individual inventors. So this is a good vision. That's what I say. It's a vision. And they have their own fungible token for exchange. So in the future, because nowadays, not every people invest on the patent because they don't know it. They don't know technology, so they invest on the house, the land. But if the system is well trusted, so you can quickly understand the pattern value, pattern quality. So any outsider, if they have extra money, they could invest on the pattern. So sell pattern licenses, small pool, service data, technology administration, patent-based securitization, financial people, insurance people, consulting people, all people who are interested in patent, they could involve and could make the patent a big business. Otherwise, a lot of patent, they will waste. They just sit in the company, become a burden. So they create a new interaction with human being. So you use the power of blockchain, AI, data mining, predicting technology. They could unlock the global patent value and make every step of process easier, simpler, cheaper, faster. That's the original plan. The leverage is this pattern. They could make it free and easy because the evaluation actually is free. They're openly free, but people are afraid to use it because they are worried if I use your system, and then this system owner may know the value of the pattern. So sometimes third party, we are the third party, we can help client to conduct a search. They feel more secure. Otherwise, whatever you move, every move from the between the competitor, they could guess what direction you're going on. So when you have new idea, you buy a new patent. Sometimes the buyer, seller, they don't want other people to know. They don't want to make a big news. They could make the cost different, or they may jeopardize some business strategy or the litigation ongoing. Then here, who owns the patent, identify the most basic critical attributes of the patent. And they make today's patent transaction, licensing, acquisition easier, faster, simpler. As I have shown, today's tools only cause you to few clicks and few typing. Of course, you have to practice from time to time. You need to understand the data behind. You need to have some basic background. That's why you try so hard to join this summer school or study in school, whatever. The efforts, that does pay back for later, how you can apply this system, feel the joy and pleasant and benefits of using these systems. They are never difficult to be practiced, but it's difficult to interpret it. They give you so many impactful information, but you are the person to make the decision. To enable new type of pattern transactions, and they promote the system. They could improve the liquidity. So I quickly go through a summary. We can have a 10 minutes discussion. So the freedom to operate, clearance to opinion, right associated to patent owner, so clear, so transparent. Patent infringement could be the basic liability for the seller. Information help you to design a run. You can collect necessary related patents. You can prepare future merger, licensing, settlement. You can generate new IP for future business and also avoid the risk. You can provide evidence for the current environment, avoid willful infringement in the future. You can easily make the investment worthwhile. Clearance search could be done. And when you have to do the search, compare the process for device with claim, review file wrapper, validity. And when you should do the search, prototype, design free, you don't have new idea, you can search other people's patent to get new idea and design a run. When we want to sell, to manufacture, or you want to launch a follow-up product, or you receive a warning letter, or you have been sued. So they support IP strategy, merger acquisition. You can help you to understand the threat and opportunities. They could support business product objectives, find out a competitive advantage. They could support decision making. But we will not be replaced by AI, as you have seen so many data, decision making by us. Okay, so we can prepare a case much easier. That's why TSMC can fight back in 5 weeks. Otherwise, for those patterns in old days, you may spend 3 months, 5 months for preparation, and minimize the refuse risk. Estimate the likelihood of success. And so I think this is very meaningful. They could help you to find out your potential. This is a real Japanese case. For example, they have the printing. They have the printing technology, but you know the inkjet is already replaced by the laser jet, right? Laser printing. So their printing technology, what can they do? They can apply to painting on medicine, coffee, biscuit, inhalation medicine, semiconductor. But you have so many opportunities. Where should you go through? So we have the population. It means we have the pattern mining globally, text mining cluster, get into the group, identify application, find out what is the potential direction you can do, and who is the potential partner. This is for finding partner because their technology going to phase out. They need to find new partner to cooperate. And then after they have done all the analysis, human efforts, after those advantages, disadvantages, SWOT analysis to decide whether they would like to use their technology, work with Johnson & Johnson or iRobot or which city or Intuitive Surgical, Cisco, Samsung. So this is based on the corporate resources, but IP could turn out to be the strategy backup. So that was another case. So the current progress today's course is very grateful by Nanjing University of Science and Technology and WIPO. They coordinate to conduct this class. But actually, China has become the biggest patent filing and patent litigation zone for the world. So it's so obvious that U.S. legal profession no longer exclusively drive the U.S. intellectual property law to push the world follow U.S. will. That's true, and this is the fact. And intellectual property, the technology, they changing the law. So you know the big data, the chatbots, whatever, the patent can be dropped by AI, contract can be dropped by AI. We have been discussing inventorship ownership for the past few days, and so you have understand prior search, patent identity, acquisition, asserting, and investment. They all can be supported by AI, big data, predict technology, machine learning. But what will be our value? So you need to learn more. You need to catch up. Otherwise, maybe one day, it's the law. Maybe they could be called it. It's the analytic action better than us. Then it's a software. Of course, software is there. They are not smart enough to replace us all. But now the lawyer, they no longer need the office. The cloud-based, what would be the liability if it was hacked? And can our experience one day be coded by the machine? So a lot of questions, and that's my presentation. I have given you 2 chapters from my books. If you want more, you can contact me. And that's my presentation today. We still have a few minutes for the questions. So you're more than welcome. Anyone would like to ask questions? This is the end of my presentation. And you will have my presentation, my PPT, so don't worry about it. And you're welcome to contact me later or join my later class. So any questions? I have to stop sharing though, so our moderator could help. So I stop sharing first. Okay, so Dr. Ching, can you help to moderate the Q&A sections?
Yeah, okay. Thank you, Professor. Thank you for your insightful and functional teaching. Okay, everyone, if you have any questions, please just type in the chat box, or you can directly raise up your hand and open your microphone and camera if you get the permission.
You can speak Mandarin, I understand. You speak English as well, I'm fine, but only English and Chinese, I understand.
Oh. Any questions? 有问题吗，各位同学？
There is a question from Yu Deng,
Okay.
Nanjing University of Science
Okay.
and Technology, and thank you so much for the amazing presentation. And I have a question. Is I realized the AI and the big data technology can be used in the pattern analysis. You can get some the pattern value analysis or more accurate pattern information. And I think maybe this technology can also be used by NPE, right?
Yes.
I mean, they can also in some patents acquisition, they can buy some patents more accurate and sue others more accurate.
Yes.
They may also increase or stimulate the problem by the
more
NPE.
litigation.
Yeah. I think this is also is a problem because in our mind, the patent system is stimulates innovation, but some NPE or problem caused by NPE also stretch the innovation. Maybe in the foreseeable future, we can talk about more about how to balance it or how to solve its problems. Yeah, this is not a question, but I just want to communicate with you about some idea about this. Yeah.
Okay, so if you remember our presentation, the tool is owned by the third party. There are many tools. If you pay, you can use them. So the NPE or the manufacturer company, big companies, they can also buy different systems. So that's why I use two to compare with you, pattern cloud and also IP with, because I work with them. They give us free to train students. But you may have an InnoGraph, or I know InnoGraph used by Shanghai University. They have trained students to do that, and also a lot of the tool. So my point is, I think the young generation. I'm 55, right? So for the young generation, you definitely have to learn that. You need to have your current knowledge from the book, from the classroom. You need to at least try master one or two tools, and you quickly can use the other one, and that will be your competitive advantage. Otherwise, in old days, only the old attorney will survive. The middle part, the middle level of the work, or the junior work will be replaced by machine. But either party, even the court, they have used AI to calculate the more neutral or more trustworthy damages. For example, TCL versus another competitor. That was last year, TCL case. TCL, they have successfully used another system we didn't introduce today to prove the NP, the patents, their patents are not so many NP, not so many essential standard patents, and the value, what will be the reasonable value for the damages. So everybody can use that. The court can use that, defendant, plaintiff, but whoever did not catch up will definitely alter market. That's the fact.
Okay, thank you so much.
Okay. Any other questions? Don't worry about the technology. The more you learn, the more you practice, the more you gain the experience. And the essence of this IP industry, IP career is the more you learn. A company by your age, you will be more experienced. And certainly, if you master with this new technology, new tool, you don't have to be afraid of those very senior attorneys, those 80 years old, 70 years old, because in old days, you only trust those people that have a lot of experience to win the case. But I think AI and big data, they cut down the entry barrier. That's a good and as a merit for the youngest.
Yeah, sure. Because I think, I mean, there is no too many NPEs in China. But there are too many in America or the European country.
In Europe, but actually there are more. They are moving to China, so that's your business. The more litigation, the more business for you all. So congratulations, you are in the law business.
Thank you.
Okay. So if there's no question, you can if feel free to email me or write me later, ask me question later. That's not a problem. So we have 1 more minute. 讲中文也 OK. If you want to ask question by Chinese, how you can learn this? Because I think some experience sharing is also important. How we start from a scientist. I start chemistry. I start to learn the law from my age 36. I went to the evening school to study law. After I got my law degree, I start IP career. They would start from my 40s. So now I'm 55. It was 15 years. It's a very interesting journey, I believe, from how you study start from the laboratory in the experiment, see the product be patent protect, become the new product, and finally facing the litigations and how you overcome those problems and become rich. So this is our final goal. Be knowledgeable, be rich. I think that's very good for learning IP and learning law. And thank you for all today. So may we close today's class? Okay, Dr. King, can you just make some close remark, or we can just say goodbye to everybody? Good evening, good morning, good afternoon, no matter where you are.
Okay, I believe we've learned a lot from today's course, and I also believe that there are still many questions worth to be discussed. But due to time constraints, we have to end the course today. And if you still have questions, you can contact with Professor Wang with email. Okay, thank you, Professor. Thank you again for your wonderful presentation.
Okay, so I will type my email here so you can have it.
Oh, okay.
Okay. Okay, so you have my email.
Yeah.
And WeChat as well. So see you and good night.
Have a good rest. See you tomorrow.
Okay, so can we? Okay, bye-bye.
Bye-bye.